The California administration and distribution of estate assets can raise many questions, and families faced with these questions seek answers. Wills, trust, insurance policies, bank accounts, and securities are subject to different laws. And this video is about intestate estates, those where the person has died without a will. I'll use this fictionalized account to explain how intestate heirs may divide estate assets by agreement. And I'll cover some of the reasons that people do this. Mom, a widow, dies without a will. At the time of her death, Mom owns a Castro Valley house in Alameda County, and the house is titled solely in her name. The house does not have a mortgage on it. It's valued at $840,000. And she also has a $700,000 account in the Fremont Bank. The bank account is Mom's name alone. Beth, Margot, and Vic are Mom's 3 children, and they survive her. Beth works for Apple in Cupertino, and she owns $7 million in Apple stock options. Beth has a home in Los Gatos that's valued at over $1.6 million. Margot is a middle school teacher in the Fremont Unified School District, and she earns approximately $85,000 per year. Her husband is a veterinarian in Union City, and they have a home in Pleasanton. Vic, their brother, is a disabled veteran with 100% disability. Vic receives approximately $3,250 per month in VA compensation. He has a spouse and a child. Vic's spouse, Sheila, works for the Department of Veterans Affairs in Palo Alto as a senior social worker, and she earns approximately $70,000 per year. Vic and Sheila rent a duplex in the East Bay for $2,600 per month. And they have a rough time making ends meet. Beth, Margot, and Vic are close as siblings. They go together and meet with a probate attorney to discuss the administration of their mother's estate. The estate attorney explains that the estate assets will be split evenly between the 3 of them. Beth says that she doesn't really need the money, and she asks whether it would be okay to provide or to give her money to benefit Vic. Margot says that she and her husband are also very well set, but their really only need is to provide for about $300,000 in combined private college tuition for their 2 children. Margot says that, like Beth, she wants to help her brother and his wife, Sheila. The 3 siblings agree to split assets differently than the split defined in the probate code distribution. Under their agreement, Vic will get the house. Since the house is free and clear, Vic and Sheila will find Bay Area living far more affordable. They believe that living rent-free and having an opportunity for home appreciation will dramatically change their financial outlook. Beth agrees to completely forego any money from her mother's estate. She'll happily receive her mother's personal effects and mementos. The 3 agree that Margot should take $500,000 of the Fremont bank account and distribute the remainder to Vic and to his wife, Sheila. Beth, Margot, and Vic sign an agreement that they, being the heirs of Mom, agree that the assets of Mom's estate shall be distributed, notwithstanding California Probate Code Section 6402 or any other applicable section, as indicated above. Legal counsel can help them prepare the agreement if desired. Now, the story of Mom, Beth, Margot, Vic, and Sheila is fictional. While fictional, it contains truths that we sometimes see in California estates. Surviving siblings will try to arrange an estate plan that was really never arranged in their parents' lifetime. And this is not an easy thing to do. It would be better to have an estate plan that meets the desires of the person who owns the assets during her lifetime. Still, families are commended, and we must commend them, who at their own expense make the effort to do the right thing. I admire this when I see it. Hackard Law represents foreign, out-of-state, and California families in California Superior Courts in cases that involve wills, estates, trusts, and elder financial abuse matters. Call us at Hackard Law, 916-313-3030, if you'd like to speak with us about your case. Thank you.